Publishing legally obtained information, presented by Mark Schulz, Jillian Williams, and Teyuna T. Darris. The First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. The questions. The main question is, was this information legally obtained? And the second question, was there a legal search warrant issued? These are the exclusionary cases. Each of these cases involve illegally obtained information and the 14th Amendment. These cases involve prior restraint versus First Amendment protection. Number 2, what do these cases have in common with the problem? All of these cases are similar with the problem at hand in that they all deal with information that was obtained in one way or another and was considered to be of public interest. The information was obtained and subsequently published or released via article, television broadcast, or radio airwaves. Here are the facts. In the New York Times Company versus the United States, the New York Times gained access to articles based on a study in regards to the Vietnam policy. After analyzing the articles, the company started to begin publication. The United States wanted to deny publication of the articles, stating that the articles would be a national security risk. In Cox Broadcasting versus Martin Kahn, a reporter who worked for a television station owned by the Cox Broadcasting Corporation broadcasted the name of a deceased rape victim. The victim's father sued the corporation, claiming invasion of privacy. In Oklahoma Publishing Company versus District Court, an 11-year-old boy was charged with shooting a railroad switchman. During his detention hearing, a reporter representing the Oklahoma Publishers Company had access to the courtroom and therefore had access to the young man's name. While exiting the courtroom, a photographer who also worked for the company took pictures of the 11-year-old, and shortly after, his name and picture was being mentioned in newspapers, radio broadcasts, and on television stations. In the Florida Star versus BJF, a rape victim identified by BJF reported to the Florida Sheriff's Department to report that she had been robbed and sexually assaulted. After preparing the report, which including the rape victim's full name, the department left the report in his press room where access was unrestricted. It was then that a local Jacksonville newspaper reporter from the Florida Star had access to the room and obtained a copy of the full report. The reporter copied the department's report verbatim, which was subsequently published in the newspaper's police reports section. In Bortnicki versus Vopper, an individual intercepted a telephone conversation between the chief negotiator for the Wyoming Valley West School District Teachers Union and a teacher at the Wyoming Valley West High School in regards to negotiations for the teacher's new contract. The recorded conversation was given to the president of the Wyoming Valley West Taxpayers Association, which was an organization formed to oppose the teacher's new contract. The president gave the recording to a local radio host, who in turn played some of the conversation over the air. The precedents. Are the rulings made by the judges all based on the same precedent, or just some? In New York Times versus the United States, we have Shinek versus the United States in 1919, Near versus Minnesota in 1931, Hirabayashi versus U.S. in 1943, the Youngstown Sheet and Tube versus Sawyer in 1952. And Bantam Books Incorporation versus Sullivan in 1963, the New York Times versus Sullivan in 1964, and Organization for a Better Austin versus Keefe in 1971. In Cox Broadcasting versus Morton Kahn, Justice White holds the court has nevertheless carefully left open the question whether the First and 14th Amendments require that truth be recognized as a defense and a defamatory action brought by a private person as distinguished from a public official or public figure. In Oklahoma Publishing versus District Court, the court correctly observes that these are content-neutral laws of general applicability, which serve recognized interests of the highest order, the interest in individual privacy and in fostering private speech. It nonetheless subjects these laws to the strict scrutiny normally reserved for governmental attempts to censor different viewpoints or ideas. In the Florida Store versus BJF, the court finds its results compelled or at least supported in varying degrees by three of her prior cases: Cox Broadcasting Corporation versus Kahn, Oklahoma Publishing Company versus Oklahoma County District Court, and Smith versus Daily Mail Publishing Company. This is Justice White, with whom the Chief Justice and Justice O'Connor joined dissenting. In Bartnicki versus Vopper, Chief Justice Rehnquist, with whom Justice Scalia and Justice Thomas joined dissenting, the court holds that all of these statutes violate the First Amendment insofar as the illegally intercepted conversation touches upon a matter of public concern, an amorphous concept that the court does not even attempt to define, for the court's decision diminishes rather than enhances the purpose of the First Amendment. Number 4, common legal terms of art. Are there legal terms of art that are common in these cases? The legal term of art that was common amongst the cases was prior restraint. So what is prior restraint? Prior restraint is one of the fundamental rights guaranteed by the First Amendment to the United States Constitution. It is an attempt to prevent publication or broadcast of any statement which is an unconstitutional restraint on free speech and free press, even in the guise of anti-nuance ordinance. It prohibits the government from banning expression of ideas prior to their publication. The statutes. Are there statutory laws that apply to these cases? In Bartnicki versus Vopper, the statutes are Smith versus Daily Mail Publishing Company and Harper and Row Publishers Incorporation versus Nation Enterprises. In New York Times versus the United States, the narrow reach of the statutes was explained as covering only a small category of classified information, a category which is both vital and vulnerable to almost unique degree. In Cox Broadcasting versus Kahn, this court has jurisdiction over the appeal under 28 U.S.C. Statute 125.7, Section 2. In the Florida Star versus BJF, the Florida Statute Section 794.03 of 1987 makes it unlawful to print, publish, or broadcast in any instrument of mass communication the name of the victim of a sexual offense. In Oklahoma Publishing versus District Court, the statute is Section 793 of the Espionage Act. It was cited by Attorney General John Mitchell as a cause for the United States to sue to bar further publication of stories based upon the Pentagon Papers. The statute was spread over these 3 pages of the United States Code, annotated, and the only part that appeared to apply to the time was 793, Section E. The issue is whether information obtained by the media is protected by the First Amendment to the Constitution or is excluded by state law, prior restraint, or exclusionary rule. Conclusion. Barring a finding of an illegal search warrant, the Star can proceed with publication based on cases from 1971 to 2001 in which the Supreme Court has found this type of information to be legally obtained. The Star's risk is the risk of legal costs. Here are the works cited in this presentation. The end.